Good morning. Are you Braxton Hughes? And this is 25 DCCR 1124. Mr. Hughes was previously in court, entered a plea of guilty to burglary of a habitation. The agreement was for a cap of 4 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
None aware, Judge.
Obviously, I'm aware of some of his criminal history, others not quite so much. I would think that the 4 would probably be on the low end in your opinion, but I would defer to whatever you think.
Okay, thank you. Mr. Parker, you may proceed.
Your Honor, I mean, I've talked to him and I've heard some stories in my life, but I feel that he's telling the truth, not that it's a defense, but they were getting pulled over. He had some other guys in the car. There was drugs in the car. They took the drugs. He leaves and goes to a house that he used to know the person that lived there. He walks in, gets him something to drink and has a thermos or something like that, and then turns around and she's standing there. He had obviously scared her and didn't know it, and it wasn't the person he knew that lived there. And he said, call the cops, and he walked outside and sat down and waited for the cops to show up. And that's what happened. It's not like he was going in there, to try to injure her. I don't think. He walked in the wrong house, and he did take the thermos or mug, and it's simple as that. I think he'd like to talk to the court, Judge, and we're asking for probation, Judge.
Before we dive in, just a quick note. This commentary is created for educational purposes, designed to help those who may be confused or curious about courtroom processes. If you don't find it helpful, feel free to skip ahead. But for those who want a deeper understanding, stay tuned. It's about to get intense. What you're watching right now is a defendant trying to frame his burglary as a mistake fueled by addiction. But here's where it gets serious. When someone pleads guilty under a capped agreement, the judge still has full discretion within that cap. And once criminal history enters the picture, everything changes. Watch closely, because in Texas courts, prior record isn't just background noise. It can determine your future. The question is, will the judge see addiction recovery or a pattern that never stopped?
All right, go ahead, Mr. Hughes.
Your Honor, what he said is correct. I can't say anything else. I was doing drugs about a year and a half, but I was like a lightweight. I took the drugs and was not really acting like myself, and I went and knocked on the door and went in there. I was trying to get away from the people I was with, but long story short, after this event, I did sober up. Started going back to church with my mom. I was in for treatment at the Right Step. I tried to get into treatment there. I was doing the paperwork, trying to get help, but I was sober for a couple months out there on the streets, and I'm not really like a typical druggie type. I don't go around and commit crimes or nothing like that.
Your criminal history would say otherwise.
This has been a long time.
I understand, but be careful how you word things, because you've been a criminal since 2002. You've got 4 misdemeanors. You've got 1, 2, 3, 4, 5 felonies. Many more that you were arrested for, and obviously doing some things that you kind of got either rejected or dismissed because of pleas on other stuff. So I understand that some of those were a long time ago, but it's still not a pretty picture.
I understand that. Most of my previous crimes and stuff, they were behind addiction and stuff. But life's a journey, and I haven't, I still was battling with addiction, but not committing crimes, this, I know, with the standing here in front of you, charged with the crime, I could understand, how it's not.
Yeah, I mean, and At what point do you go get that help before you commit a crime, you know? I do appreciate what you've done since the offense, Ms. Malfino.
Judge, I would definitely agree that this is an odd fact pattern, very odd. I feel sorry for the situation that he's in with his addiction, but I feel more sorry for the young lady who was scared out of her mind when he was in her house, acting probably like a complete psychotic animal with tinfoil on his head. So I don't know that probation at this juncture would be a viable option, Judge, or a good thing for the community, but I defer to whatever you think is best.
This right here is critical. The judge isn't just looking at this single burglary. She's evaluating history of compliance. In sentencing, especially when probation is requested, the court asks one key question. Has this person ever successfully followed supervision before? And in this case, every prior probation was revoked. That severely weakens any argument for another chance. Rehabilitation sounds powerful in theory, but courts deal in documented patterns. Would you roll the dice again if every prior chance ended in failure?
If your history had, one of the things that is sticking out is that every probation you've ever gotten has been revoked. So you've never been successful on probation.
I
And
ended up
so,
completing the last one.
huh?
I did complete the last one.
The last one that I see was the federal
Yes, ma'am.
sentence where your supervised release got revoked.
I did get revocation, but I got back out on probation and completed it.
Okay. At this time, Mr. Hughes, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff. And this is Ms. Malfino. Good morning. Are you Kashawn Purdy? And Ms. Purdy is on probation and cause number 24, DCCR 1272 for the state jail felony offense of unauthorized use of a vehicle. And there's a new indictment in cause number 25, DCCR 1523, charged with injury to a child, elderly, or disabled individual. Mr. Kimler has filed a motion asking for a bond in that unauthorized use case that has the motion in it. Mr. Kimler, you may proceed.
Your Honor, I think she's on deferred. I've reviewed a little bit. I haven't actually gotten discovery on the new case yet, but I have reviewed some photographs that were taken by the defendant's family with injuries. I don't want to downplay it, but it appears to be sort of the minimus type of injury. It's not, and I'll defer to Mr. Hawkpower, may have a different opinion on that. We're simply asking for a bond on the underlying motion to revoke probation to allow our time to prepare to defend the injury to a child case.
I can't, hold on. Y'all, I'm having a hard time. So if you're talking about a case, for some reason, I'm having a hard time. I've got a cold and my ears are stuffy. Y'all need to step in the back. If you're not talking about a case, I need you to really be quiet.
And I'll try to
Speak up, please.
Sure. And additionally, she is pregnant. I think that, and I did receive a write-up that was emailed to me from the jail. And to the best of my understanding, it appears she was wearing, I guess, a blue wristband to indicate that she's pregnant. There was some don't know, misunderstanding on the part of the jailer as to whether some other female inmate had given her the wristband. Evidently, they get extra rations or extra portions of food and their vitamins and stuff if they're pregnant. But it appears from the write-up that she actually is pregnant, so I don't know that it was a disciplinary write-up or what the purpose of the write-up is, but she certainly, other than that, hasn't had any problems to my knowledge.
All right, you want to put on some evidence with regard to her ability to pay? Would you raise your right hand the best you can? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Ms. Purdy, the judge just wants to know your ability to pay a bond, to actually come up with the funds necessary to pay a bond when you get out of jail. What's your financial situation right now? Just curious.
I had got laid off back in September, but I had got another job at the end of October. So I'll be able to pay my bond.
How much do you have available now to pay a bond, but as far as money that's put aside to pay a bonding fee to get out?
Like 500, 600.
Okay, and then hopefully after that you get your job and would be able to work?
Yes, sir.
Okay.
Yes, sir.
Do you have any savings or checking, money in the bank, anything like that?
No, sir.
Do you own your own residence, your own home? Do you own your own?
Rent, yes, sir.
You rent? Do you own any vehicles?
No, sir.
What about any other thing of value that you might own? Anything?
No, sir.
Okay. That's what it is.
I need to know, how many children do you have?
I have 2 and 1 on the way.
And where do they live, with you?
Yes, ma'am.
So if you make bond, where are you going to be living and with who?
At my home.
Who lives at your home?
Me, my 2 kids, and my fiance.
Did Child Protective Service get involved in this?
Yes, ma'am. They closed the case. And I was also taking anger management and parenting class also.
Through CPS?
Yes, ma'am.
But you didn't finish those because you got incarcerated?
Yes, ma'am.
Okay.
Right.
What's your relationship with Kamari?
It's my oldest. Yeah, I talk to her every day. She tells me every day, she say, Mama, I pray
I don't
for you."
care,
Yeah, just answer the question.
because you're not going to be allowed to be around them if you make bond. So you got to figure something else out until I figure out what's going on with your
Yes, ma'am.
case. So that's going to be,
Well,
who are they with now?
my mom.
Okay. So if you make a bond, then they're going to have to remain there. You're not going to be able to have unsupervised contact with them until further order of the court. Do you understand? That would be a condition of your bond.
I totally understand.
Okay. Mr. Hoffpower, what's the state's position?
Judge, that was our concern, is the new offense. I disagree whether or not it was de minimis or felony court.
Well, and for the record, I am reviewing the probable cause in that case, just to get a little bit of information on what the allegations are.
I was talking about a photograph, so.
What else?
Simply, Judge, that she's on felony probation and allegedly commits a felony. We'll leave it to the court's discretion.
All right, so I'm going to grant the motion to set a bond in cause number 24 DCCR 1272. I'm going to set that bond at $30,000. A condition of that bond is that you have no unsupervised contact with any children, including your own, and that you complete whatever CPS is requesting that you do. So if they started classes, you need to continue with those and whatever they request of you. Do you understand?
Yes, ma'am.
All right.
Comply with secret.
All right, you can go back with the bailiff, do it on a different day. Yeah. Okay, you're Michelle Cormier,
Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
Yes, ma'am.
Ms. Cormier, in clause number 25 DCCR 1446, let's see, are we going on with the prior or just the?
With the prior judge.
Okay, let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? And is that prior conviction true?
Yes, ma'am.
Sorry, it takes me a minute to get it pulled up. And cause number 25 DCCR 1447. You're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013. In two different cases, or three different cases on that date. And what that means in that case is that would be enhanced to a third-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Yes, ma'am.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes.
State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before
Yes, ma'am.
The hearing, that would be great. All right, thank you. You can go back with the bailiff.
I did.
Yes, sir, thank you. All right, you are Kadesha Eli.
Yes, ma'am.
And Ms. Eli was previously in court, entered pleas of true to a motion to revoke probation on probation for injury to a child, elderly, or disabled individual. Entered pleas of true to counts 1 through 8. I've received an updated report. Has everyone had an opportunity to review that report?
Yeah.
Are there any additions or corrections?
Come from the state, Your Honor, unless Ms. Lopez has anything additional to her updated PSI.
All right, thank you, Ms. Lopez. And there was not an agreement, correct?
Correct.
Mr. Lewis, you may proceed.
Well, Judge, Ms. Eli, like I said, was previously placed on probation out of this court. Early on during her probationary period, it seems she had been doing really well, doing well, or has been able to comply with the terms of probation. During that time, of course, she's started having personal setbacks as far as her living situation, as far as where she would live and things of that nature. I believe at some point she did talk with probation about that, as far as trying to get some help with that. And it seemed to be working out well, even gotten to, I think she was living with your mother, your grandmother. And it seemed to try to get back on track, but at some point that situation didn't work out for her either. And that's when things started to really go downhill fast as far as the not reporting and things of that nature. And it snowballed on her. Since she's been in custody, she has been able to secure a more stable living situation, of course, with her brother. that will be available to her if the court decides to reinstate her. Also, employment. She has some employment options that's available to her as well. That I think that was her main problem or issue was stability. And I think since during this time, while she was already searching for these options, Judge, but they unfortunately by the time they became available to her, she was in custody. Now, when I talk about the situation with her brother for the living situation, that's also one of the job situations as well. Her brother works with Zumo Sausages, the Zumo company, and she actually worked there for a temporary period of time a while back, early on, and that job fell apart, but looks like it'll be open again for her to go back. So that's essentially what it comes down to. She's asking now that she's stable to try to see if she can have the opportunity to get out there and complete the probation like she initially tried to and wanted to.
What's the status of the theft in Orange, the new offense?
For as we know, the situation in Orange, there hasn't been a court date or anything up there. So it's still in limbo, at this point, Judge.
Okay. Ms. Malfino?
Judge, I think it's fortunate that we're not here on a violation that involves a child based on the underlying nature of this probation. But I also think it's unfortunate that she doesn't have any felony offenses, was given this many opportunities, and as this court is well aware, a very good officer to work with in Ms. Lopez, and she has not done what she has been required by this court to do. So I would stand with Ms. Lopez's recommendation and defer to any other comments she might have.
So, Ms. Eli, the problem that I have is that when you first got on your probation, we sent you to the cognitive track of ISF so that you could get tools to be able to be successful and do better and make it through probation. And when you got out of ISF, you were put on the high-medium caseload so that you would have help with all of these issues that Mr. Lewis is talking about, help with places to live and with jobs. And you were given all of that. And so for me to say, okay, you've already been given all that and you didn't take advantage of it to give you some other opportunity and just let you out when I've already given you these sanctions. And the underlying case is just very, very serious. And the fact that you got a probation was a big chance. And if you hadn't already been to ISF, then maybe I'd be thinking about, okay, let's do ISF or let's do something to give you some tools to do better. But we did that and you didn't take advantage of it. So at this time, I'm going to find that you entered your pleas of true to counts 1 through 8 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. This is not a plea agreement, and so you do have some rights to appeal. You can talk to Mr. Lewis about that. I'm handing you the trial court certification. It shows you do have that right to appeal. I need your signature on that, and I'll get you a copy of it. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, you can sign that, and y'all can take the bottom 2 copies.
It opened the wrong one in the background, that's why. Hold on a minute.
Good morning, are you Isaiah Brown? We are client waive the formal reading of the indictment. Mr. Hoffpower, this is yours on Isaiah Brown.
Sorry.
This is one of the toughest judicial decisions to make. Probation is considered a privilege, not a right, especially in serious offenses involving harm to a child. Notice what the judge emphasizes. She already gave structured support, cognitive intervention programs, high monitoring supervision. When those tools don't produce compliance, the court shifts from rehabilitation to accountability. The underlying offense here carries serious moral weight, and once prior opportunities are exhausted, prison becomes the consequence. Do you think the system gave enough chances or not enough structure?
Okay. So it's a reduction to state jail.
Yes, ma'am.
Okay. Mr. Brown, in cause number 25, DCCR 0356, the state has elected to proceed on the lesser offense of a state jail felony, abandoning or endangering a child with intent to return from February 9th of 2025. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yeah.
Do you fully understand them? Answer out loud.
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, sir.
It's admitted. Is there any evidence that Mr. Brown is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done by probation. Then we'll come back at a later date for sentencing. Mr. Hoffpower, what is the state's position with regard to a bond based on the nature of this plea?
We have no position.
What is the
Still,
what's the relationship to Kinsley Segura?
that's a child.
This is,
It's my little girl.
It's your daughter?
No, he's not with the mother.
I'm sorry?
They have custody. I'm not sure if he, what kind of.
Do you have any kind of,
No, she blocked me when she had my baby, so I'm not on the birth certificate, I'm not on none of that.
so until anything happens legally with that, you cannot have any contact with your child, you understand?
Yes.
Okay, so what I'm going to do, based on the nature of this plea agreement, between now and sentencing, is reduce your bond in your case to $1,000. If you make that bond, it's very important that the first thing you do is go to the probation department so they can start that pre-sentence report, okay? Also, a condition of that bond is that you have no contact with Kinsley Segura, okay?
Yes.
And then we'll see you back at sentencing. All right, you can go back with the bailiff.
Should be a second amended motion to revoke it.
No, on the first amendment.
Yeah, that second amended one was filed.
I can print out a copy.
I have the date that it was filed.
Looks like August 27th. So it should be the one that you have, but let me print it just to, Good morning, are you Leonard Guillory?
Yes, ma'am.
And so, Mr. Guillory, let's start with cause number 25. Is it printing? Hold on, I can't. Yeah, there it goes. All right, in cause number 25 DCCR 0902, you're charged with aggravated assault with a deadly weapon from June 19th of 2025. The indictment alleges that you were previously convicted of a felony offense, which means for punishment purposes, if you were found guilty, you would be considered a first-degree enhanced, and the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would run at the same time as a 10-year term in that motion to revoke your probation case. You have every right to reject this offer and have this case set for trial. I do want to make sure you understand what the possible consequences are and what your options are. And do you want to reject that offer and have that case set for trial? So what we're going to do now, Mr. Guillory, is go through that motion. I'm going to get pleas of true or not true on that motion, and then we'll have a hearing on that motion first at a later date. I'll make a decision on that motion, and then we can go forward with your trial after that, okay? So will he waive the formal reading of the motion?
He does, Judge.
In cause number 22-40982, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation June 26th of 2024 for unlawful possession of a firearm by a felon, a third-degree felony, and that was a 7-year deferred probation. Is that correct? Speak up, please.
Yes, ma'am.
Thank you. And it alleges that you violated your probation. Count 1 alleges that you committed the offense of burglary of a vehicle June 8th of 2025 in Hardin County, Texas. And is that true or not true?
True.
I'm sorry?
Not true.
Okay. Count 2 alleges that you failed to immediately report the arrest from June 8th, 2025 to your probation officer. Is that true or not true?
Not true.
Count 3 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of participating in an education program for your GED. Is that true or not true? Count 5 alleges that you failed to provide verification of entering and successfully completing the Moral Recognition Therapy, the MRT program.
Not true.
Count 6 alleges that you failed to pay your court-assessed fees as directed, and as of June 16th, 2025, you were $1,140 behind. Is that true or not true?
True.
And then it says second amended, but it never said first amended, so I think it's probably what we were all thinking it was. Anyway, count 7 alleges that you committed the offense of aggravated assault with a deadly weapon June 19th of 2025, and is that true or not true?
Not true.
Count 8 alleges that you committed the offense of evading arrest or detention with the use of a vehicle June 19th of 2025. Is that true or not true?
Not true.
Count 9 alleges that you possessed a firearm on June 19th of 2025 in violation of your deferred adjudication order. Is that true or not true? All right. So did you enter your plea of true to count 6 freely and voluntarily? All right, then I'm going to find that count true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'll reset it for a hearing and ask the probation department to do an updated report. Mr. Coleman, does the state anticipate witnesses with regard to those the offenses that are alleged?
At least a couple of witnesses.
So we'll set it on a date when we're not in trial, not a docket date, so that we have time to have that hearing. All right? You can go back with the bailiff. Good morning. Are you Deshaun? Is it Vital or Vital?
Vital.
Vital. And Mr. Lewis, will your client waive the formal reading of the indictment in each case?
He does, Judge.
Mr. Vital, in cause number 25 DCCR 1107, you're charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Freely.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
And then in cause number 25 DCCR 1109, you're also charged with a first-degree felony offense of aggravated robbery from July 10th of 2025. And how do you plead in that charge?
Guilty.
And are you pleading guilty freely and voluntarily? And again, because you did what they charged you with. In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year deferred probation, that ISF would be ordered. So when is your 18th birthday?
April 18th.
Today's docket showed the full spectrum of criminal court reality: negotiated plea caps, probation revocations, bond hearings, deferred adjudication, and enhanced felony consequences. We saw addiction defenses tested against criminal history. We saw a mother restricted from unsupervised contact. We saw probation revoked after structured rehabilitation failed. And we saw plea agreements carefully walked through to ensure voluntary understanding. This is how real courtroom discretion works: structured, procedural, and unforgiving when patterns repeat. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Okay. So it'll be less than that at sentencing. So
Right.
we'll do upfront time until your birthday, and then you would go to ISF. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Vital is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So are you at Minnie Rogers or at the jail?
Judge, can I address something?
Yeah.
Obviously, Mr. Vital has been in custody for several months. He's going to continue to be in custody for several more months. While he's in the Jefferson County Correctional, he's mentioned multiple times in reports, typically he's a victim of other people's behavior. There are a couple instances where he's doing things he
Yeah, I don't
shouldn't do,
see
but
many at all.
it's not the worst of the worst. It's not my concern. I just wanted to explain to him that it's important. And the last note I saw was that he'd been moved out of a dorm where he was being victimized
Yeah.
and bullied.
Yeah.
I want him to be successful. I want him to
I
understand
do
that
too.
those reports can change. What gets reported between now and sentencing can change what happens in this case.
Sure. Thank you, Mr. Nichols. And I was going to address that. And you may have heard out there already that incident reports at the jail don't go over very well with me. I do understand there's been some things going on that weren't your doing. And so you just keep doing what you need to do to keep your head down to make it until we get to sentencing so that you can be successful. You're doing the right thing. If we end up with some reports and you change your behavior, which I don't see any reason to, you've been doing pretty well. And it sounds like the jail has taken notice of what's going on and where you need to be. But just continue doing what you're doing so that when we get back here in a few weeks for sentencing, I don't have any issues and Mr. Nichols doesn't have any issues to look at with regard to jail incident reports, okay? All right, you can go back with the bailiff. Thank you. The formal reading of the indictment. Mr. Broussard, in cause number 25, DCCR 1442, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from July 27th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you did what they've charged you with?
yes.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, If you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes.
State tenders number 1.
No objection.
We've got, it's admitted. I know, back up.
Sorry.
Is there any evidence that Mr. Broussard is not competent?
No, Your Honor.
You need one?
Thank you.
All right, Mr. Broussard, I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on the nature of that plea agreement?
Your Honor, he has a prior successfully completed probation for deadly conduct. The situation involves an in-home argument with his adult sister where he shoved her and brandished a machete. My concern would be if he was released, where would he be awaiting sentencing?
Mr. Broussard, when you are released, whether it's on a bond or when you get this probation, where will you be living?
4948 Lawndale.
And who lives there?
My mother.
Who else?
There's 2 other couples. There's Lindsay's daughter, my niece, and her boyfriend, and another couple.
Okay, where does Lindsay live?
Lindsay lives at the lake, Toledo Bend.
So you understand that you're not going to be able to have contact with Lindsay.
Yes, ma'am.
So if there's some family get together at the house where you're living, you're going to have to leave if she comes over.
Judge, I do have that address as her address in my file. I'm not saying she doesn't live at the lake or whatever.
Okay.
And I'll let the court know she called yesterday, spoke with my investigator, wanted to drop charges. But because of the evidence in this case, I think I could prove it regardless. That's why we reached an agreement this morning.
Okay, so what I'm going to do, Mr. Broussard, based on the nature of your plea agreement, is reduce your bond pending sentencing to $1,000. If you make that bond, there's some very important conditions. First, the very first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. The second thing is that you're to have no contact or communication with Lindsay Gaspard. So if she is living there, you're going to have to find another place to live. You're going to have to figure that out, okay? If I find out that you're having any contact or communication, or she contacts the DA's office and lets them know that, then you run the risk of me not accepting the plea agreement. All right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Yeah.
All right, again, you're Jacoby Frazier.
Yes, ma'am.
So, Mr. Frazier, I gave you an opportunity to visit with Ms. Holmes about your case. You had already entered a plea of guilty before, and we had come back for sentencing, and then I wanted you to visit with that doctor to make sure that you understood everything.
I understand.
And so do you want me to go forward with your sentencing today and give you that probation that y'all talked
Yes,
about? Any issues, Mr. Coleman?
No, Judge.
So, Mr. Frazier, I'm going to follow the agreement that you made previously with the district attorney. Find that you entered your plea freely and voluntarily. Again, find that you are mentally competent. Sentence you in accordance with that agreement. I'm going to defer all proceedings for a period of 4 years. You will be ordered to pay a $500 fine, and you're going to be ordered to follow all of the rules and conditions of probation. Part of those conditions are that you follow through with any treatment for mental health care through Spindletop. So if there's classes or counseling or medication, whatever it is, that's now not just part of what you probably need to do, but it's part of your probation. You understand?
Yes, ma'am.
So if you don't go to your appointments at Spindletop and you don't take your medicine like you're supposed to, then it could end up with your probation getting revoked, and you could go to prison for up to 10 years. Do you understand?
Yes, ma'am.
So it's very important that you do everything your probation officer tells you. Okay? So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Obviously, you need to be on the mental health caseload as well. Yeah, it was already done. And so you'll be released from jail today. It's very important that the first thing you do is go to the probation department. The probation officer is going to talk to you today here in court. She's going to tell you where you need to go, and you need to make sure you try to get there today, okay?
I will.
Okay, good luck. You can go back with the bailiff.
And I have the paperwork where the probation.
She's going to give it all to you. She's going to give it to you. You'll have everything in writing.
Thank you, Ms. Harmon.
You will.
Thank you, Judge West.
Yes, sir. You're welcome. Happy holidays,
Stay
Mary.
blessed.
God bless.